In the previous video, I gave you a brief overview of the sources, principles, and standards of international economic law. Now that you're more familiar with these sources, I just wanted to briefly focus on some key ideas to understand international economic law. If you're used to thinking about domestic law, you will probably think of law under the classical pyramid of norms proposed by Hans Kelsen. The problem is that this scheme is not appropriate to understand international law in general, and even less so as regards international economic law. As you will be aware, there is a long-standing controversy as to whether international law is actually law at all. The core of positivist thinking criticism relates to the absence of an independent enforcer of international law. If there is no judge to determine if someone has broken the law, and there is no police authority to enforce the law, the argument goes, there is no actual law. Now, all this depends on what your concept of law is. I will not go into this discussion here. Suffice to say that if we think of law as a form of ordering human behavior in social contexts in order to promote socially beneficial conduct and to deter socially harmful behavior, then we can see that law is not only about coercion, but rather about voluntary compliance. Just think about your day so far. I'm guessing you could probably have broken a few laws, like riding a bus without a ticket. Most likely you didn't. In fact, I do hope you didn't do it. But anyway, the important thing to keep in mind in international economic law is to account for the fact that international actors tend to act in compliance with the law. This happens despite the absence of the typical trappings of a state in the international legal order. For instance, when we think about a state legal order, the separation of powers between legislative, executive, and judicial comes to mind. Yet, there is no world legislator in international economic law. Even the General Assembly of the United Nations has only the power to issue recommendations, that is, non-binding acts. Let me focus on treaty law for the moment. Treaties do not create legislation in a proper sense. Rather, they create international obligations, and these are only binding on the parties of a treaty. So, international economic law is complex and multi-layered because we have to deal with multiple treaties, some bilateral, others multilateral, and of the latter, a few of quasi-universal membership. In a sense, each treaty creates its own legal order, although there is a system to deal with conflicting and overlapping obligations under the Vienna Convention on the Law of Treaties. So, if we think of the World Trade Organization, we can say that it forms its own legal order, that is, binding on member states. As we shall see later in this course, this does not mean that WTO law is autonomous of international law in general. And what about the judicial system? Well, we do have the International Court of Justice, yet its jurisdiction is only compulsory on states that have accepted it. The US, for instance, has accepted it with reservations. Furthermore, with regard to the workings of international organizations, it has an advisory capacity. In fact, there are many other bodies that fulfill this judicial function. Some are ad hoc arbitral tribunals, like in investor-state dispute settlement. Others have the form of a seemingly technical body, but actually operate as powerful international courts, as we will see in the WTO system. In any case, one thing is clear. There is no organized hierarchical judiciary, and that has a significant impact in the development of international economic law. Finally, there is no executive. So, if an international actor breaks the law, you cannot appeal to a global police force. This means that, unlike what happens in the domestic legal order, where the state has a monopoly on the use of force, in the international arena, we often see self-help as the system to enforce international law. Needless to say, this is an unbalanced structure, as powerful states get to enforce what they see as their rights through, for instance, economic sanctions, whereas less powerful countries have little choice but to put up with breaches of international law and make the usual diplomatic protests. Remarkably, we will see that in international economic law, there are a few such remedies that try to achieve a more balanced system of enforcement. We will return to these topics along the course. For now, I hope you enjoyed the video, and I'll see you in class.